Today's topic is compounding and adjudication of offences under the Companies Act 2013. Under Companies Act 1956, there was no provision for adjudication. When the Companies Act 2013 came into force, still the adjudication provisions were not there earlier. So the government of India felt that most of the offences under the Companies Act are technical in nature. So in process of decriminalization of the offences, the government introduced in adjudication process so that the matters can be settled early and offences are compounded or settled through adjudication process. So let us first understand the compounding of offences. Section 441 deals with compounding of offences. 1 minute. And section 441 was notified on 1st June 2016. Now, section 441 starts with non-obscenity clause and overrides the provisions of Code of Criminal Procedure relating to compounding of offences. So, 441 overrides CRPC provisions relating to compounding. Then, what is meaning of compounding? The word compounding is not defined anywhere in the Act. As per Black's Law Dictionary, compound means to settle a matter by money payment in lieu of other liability. Why one goes for compounding? So that there should not be any stigma that you have violated so-and-so the provisions of the Companies Act. Because if the offense is not compounded, then only courts left to the ROC is to file prosecution. The Oxford Dictionary defines the word compound as to settle a debt or other matter in exchange for money or other consideration. So compounding means once you compound the offense, then it is treated as if you have not committed any such violation. As per section 320 of Code of Criminal Procedure, compounding means to settle between the two rival parties settle by entering into compromise. Compounding on offense means in order to restore harmony between the victim and the accused, they resolve their disputes amicably and peacefully. In simple words, compounding of offense means to give an option to the offender to pay money instead of lengthy prosecution procedure to avoid time of court/criminals. Now, what is the meaning of offense? Under the Companies Act, there are offences which are of continuing nature, which are one-time offense, and which are annual offences. So the word offense is not defined in the Act. Section 3, subsection 38 of the General Clauses Act 1897 defines the word offense as offense shall mean an act or omission made punishable by any law for the time being in force. In simple words, anything punishable under the Act is an offense under the Act. So what are the continuing offenses? Supposing the company has not appointed a company secretary or has not held AGM, then it is a continuing offense till you make it good. Supposing company secretary is not appointed, till such time the company secretary is appointed, the offense will continue. Supposing AGM has not been held, till such time you hold AGM, the offense will continue. It will be treated as a continuing offense. One-time offense, that means if you have committed an offense, just like you have not held board meeting in a quarter, then that is not a continuing offense because it is one-time offense. Now, small companies have to hold only 2 board meetings. Supposing one board meeting has been held, another board meeting has not been held. So, so far as a second board meeting is concerned, if it is not held, then it will be treated as one-time offense. And because you cannot hold that meeting which is required under the statute within 1 year, then it cannot be held anytime thereafter. Annual offenses, disclosure in board report, financial statement, etc. Because you hold this a board meeting for approval of accounts once in a year, so it is an annual offense. Who will be considered as officer in default? Now, it is very important to understand the definition of officer in default, because the Companies Act 2 subsection 60 defines officer in default, and officer in default in various sections it is mentioned that in case a violation is made, then the company and every officer who is in default shall be punishable. That means no other person other than the officer in default can be punished for that violation. Now, what section 260 says? Who are there? Officer in default, whole-time member, whole-time director, key managerial personnel. Key managerial personnel under Companies Act 2013 are whole-time director, managing director, CFO, CEO, and company secretary. They are known as KMP. So if company is a whole-time director, he will be responsible. If company is required to appoint other key managerial personnel, just like CFO, CEO, or company secretary, they will be treated as officers in default. Where there is no key managerial personnel, such director or directors as specified the board in this behalf and who has or have been given his or her their consent in writing to the board, then he shall be responsible. Supposing there is a private limited company which has 6 directors. Now, the company doesn't have whole-time director. Company is not required to appoint key managerial personnel under section 203. Then all the directors will be responsible for any violation. But there is an exception. Exception is that if all the directors, they appoint one of the director with his consent, that in case of any violation taking place, such other director will be responsible, then he has, his consent has to be obtained, form has to be filed with ROC, and in that case, only that director who has taken responsibility for compliance will be treated as officer in default. Then, 4, any person who under the immediate authority of the board or any key managerial personnel is charged with any responsibility including maintenance, filing, or distribution of accounts or records, authorizes, actively participate. Now, officer on default may include any person who has been given a responsibility for maintenance, filing, maintenance of accounts and record. He will also be an officer of default. Then 5, any person in accordance with whose advice, direction, or instruction the board of directors of the company is accustomed to act, other than a person who gives his advice to the board in a professional capacity. So if the board is accustomed to act on direction or guidance of any person, then also that person will be responsible. So kindly see the definition of officer in default very closely. Now, what are the advantages of compounding? Why we should compound any offense? Advantage is no personal appearance for officer in default as in case of prosecution for an offense in the criminal court. No further prosecution shall be initiated either by registrar once the offence is compounded. No prosecution can be initiated either by registrar, shareholder, or any person in respect of that offence after compounding. Summary proceeding, the compounding is a very summary proceeding. Generally, it hardly takes 15 to 20 minutes. In compounding, less time consuming. The compounding fee cannot be more than maximum fine levied under the relevant provision. So compounding fee is restricted up to maximum fee as provided under any sections of the Companies Act. No appeal against order of composition of as the order is passed with the consent, because the compounding orders are passed with the consent of the party concerned. So no appeal can be filed. Now, under section 439 of the Companies Act, or the offences under the Companies Act are non-cognizable except the offence under section 212 subsection 6. That means where the offence is not compoundable and section 447 is attracted. Now, court to take cognizance of offence, the court will take cognizance of any offence on written complaint by registrar, shareholder of the company, or the person assigned by the central government that behalf. In case of offences relating to issue and transfer of securities, concurrent power has been given to SEBI. As per section 212 subsection 6 of the Companies Act 2013, notwithstanding anything contained in the Code of Criminal Procedure 1973, offence covered under section 447 of this Act shall be cognizable. So one has to go through the provisions of section 447 of the Companies Act, which deals with one minute. I will. It deals with punishment for fraud. So you have also to refer section 448 of Companies Act. It says punishment for false statement. If any person files, any company files any document or any statement or any return which is false in material particulars knowing to be false, or which omits any material fact knowing it to be material, then it will be treated as a false statement. Then 449 of Companies Act provides that if any person intentionally gives false evidence upon any examination on oath, if any affidavit is made, then which is false, he shall be punishable with imprisonment for a term which shall not be less than 3 years. So, what I request the participants to go through the provisions of section 447, 448, 449, and 450 of the Companies Act 2013, because it deals with fraud, false statement, and the punishment which is prescribed there. Which offences can be compounded? If you go through the various provisions of Companies Act, you will find that certain offences are punishable with fine only, and the word used is fine. And certain offences are punishable with fine or imprisonment, or both, or fine or imprisonment. Then wherever the word used is fine or imprisonment, or both, or fine or imprisonment, then they are all compoundable. And compoundable by whom? If the offense is punishable with fine only, then if the amount of fine is up to 25 lakhs, then the offense is compoundable by regional director. And in case the offenses are punishable with fine or fine or imprisonment or both, and the amount of fine exceeds 25 lakhs, then it is compoundable by NCLT and not by RD. Then which offences are non-compoundable? So offences punishable with imprisonment only, wherever the word used is punishable with imprisonment only, it is not non-compoundable. Offence punishable with imprisonment and fine, imprisonment or fine compoundable, where the word used is imprisonment and fine, it becomes non-compoundable. Where investigation has been initiated or pending against the company, in that case also the offence cannot be compounded. Now, what is the procedure? If fine only, application is made to ROC. ROC then will forward to RD or NCLT. ROC will forward to RD if the amount of fine is only up to 25 lakhs, or in more than 25 lakhs, the ROC will file, it will be compoundable by NCLT. And application in Form MGT 9 of NCLT rules is to be filed before NCLT. Now, the practicing professionals like chartered accountant, company secretary, cost accountant, under section 432 of Companies Act 2013, they are authorized to represent any party. A party to any proceeding or appeal before tribunal or the appellate tribunal, as the case may be, either appear in person or exercise one or more chartered accountant, company secretaries or cost accountant or legal practitioner or any other person to represent his case before the tribunal or appellate tribunal, as the case may be. Now, we see before Companies Act which provisions were applicable. Procedure was provided earlier under Companies Act CLB Regulation 1991. Application was required to be filed in Form 3. Then it should be accompanied with affidavit verifying the petition. Then notice of hearing issued, memorandum of appeal was filed in Form 5, and no fees was prescribed. Now, after enactment of Companies Act 2013, NCLT rules 2016 have been notified. So NCLT rules are applicable. General heading of the form is form number NCLT 4. NCT 4 application is made in form NCLT 1. Affidavit is made in form 6. Notice of hearing is issued in form 5, and memorandum of appeal is in NCLT 12. Now, procedure to compound an offence. What is the procedure which is to be followed? First, if the company is involved, then a company has to call a board meeting as per the provisions of Companies Act and Secretarial Standard 1 issued by ICSI. Then company has to calculate what is the total amount of fine which is prescribed under any particular provisions of the Companies Act. The board of directors will calculate the amount of fine as per the relevant section. Then board has to pass a resolution. Board of directors will pass a resolution for filing of application with appropriate authority for compounding of offence and assign director of the company for preparation and signing of document. In the board meeting, the board will also authorize some professional who may be chartered accountant, company secretary, advocate, or cost accountant to appear on behalf of the company. Our company can represent in person also through authorized representative. Then compounding application is to be prepared as per NCLT rule. Then the application for compounding is to be filed in Form GNL 1. Compounding application shall be submitted electronically to ROC in Form GNL 1 along with payment of applicable fees. the following documents shall be attached to the compounding application. Now, at this stage, I would like to say, if there is a company and officers and default, that means KMP, the whole-time director, manager director, company secretary, etc., or any other person who is to be file compounding application, a joint application can be filed by the company as well as by KMPs and other persons. So what should be the content of the compounding application? Then the application should be prepared in prescribed form. Format is given in NCLT form number 9. Affidavit verifying the petition, memorandum of appearance in form NCLT 12. In case of advocate who is authorized to appear, Vakalatama, along with the board resolution. Then board resolution giving authority to sign the application or petition. Evidence showing the offence is being made good. No offence can be compounded unless the same has been made good. That means if you have not filed any form, DIR 12 or AOC 4, MGT 7 or any other form, then first you file the form. Supposing company has not appointed company secretary, then it not only it is a continuing offence. Offence cannot be compounded unless you appoint a company secretary. So offence should be made good. That is precondition. ROC RD notice in case received any. Supposing ROC has given so-called notice, still you can file a compounding application, but the copy of the so-called notice should be annexed to the compounding application. Any other relevant document which may be annexed. Now, who can file application with ROC? Inform the Honorable. An application can be filed by company, director, manager, others, and in one application, 8 persons can together file a single application. For additional person, the optional sheet is to be attached. In case of director, DIN, manager, secretary, PAN, all these particulars should be given. What is the number of the director, manager, the PAN of director, manager, company secretary, the copy of passport, etc., have to be annexed. Applicant, if the applicant is company, then director, secretary, manager, CEO, CFO of company duly authorized by the board of directors can sign the application. Then in case of foreign company, authorized representative can file. Individual who does not have a DSC by practicing professional. Now, once the application is filed, the ROC will submit the application to the appropriate authority, who may be regional director or NCLT. Now, if it is before NCLT or RD, you will receive notice of personal hearing. A time will be fixed, date and time will be fixed. At that date and time, you have to remain present either in person or to a site representative before RD or NCLT. And then after hearing the person concerned through the site representative, the necessary order, speaking order shall be passed. One thing should be noted here, that order will be issued only after you are making payment of the compounding fees. So once the hearing is over, you are communicated how much compounding fee is levied on the company or on the directors, on the KMP and others, and then payment has to be made. And payment has to be made in case of company by company. In case of directors, KMPs, etc., company will not make any payment on their behalf. Such directors, KMPs have to make payment of compounding fees out of their own pocket. So after making payment and after generating challan, that payment has been made, then you submit the paid challan to office of the RD or NCLT, then only compounding order will be issued. Where an offence is compounded, initiation thereof shall be given by the company to ROC. Now, compounding order has been made, then it has to be communicated to the ROC within 7 days in Form INC 28, on which such order is made available to the applicant or petitioner. Where any offence is compounded before any institution of prosecution. Now, supposing ROC has already filed prosecution before the court, magistrate court, still compounding application can be filed. Earlier, in case the prosecution has already been filed, then no compounding could take place unless permission from the concerned court was taken. Now that requirement has been done away with. No prosecution shall be instituted in relation to such offence after the offence is compounded. You communicate to the ROC. ROC will in turn communicate to the concerned court that offence has already been compounded. Then that prosecution case will stand withdrawn. Where the compounding of any offence is made after institution of any prosecution, such compounding shall be brought by that I have already told. Now next, the tribunal or regional director or any officer authorized by the central government, as the case may be, while dealing with a proposal for compounding an offence for a default in compliance with any provision of this act which requires a company or its officer to file or register or deliver or send to register any return, account, statement, etc. by an order, if it hears, he thinks fit to do so. Then supposing any application is filed for compounding, some return, some form has not been filed, the ROC has already direct, NC may direct the company to file such form. Then if any officer or other employee of the company who fails to comply with any order made by tribunal, now if there is non-compliance of the order passed by the tribunal or the regional director or any officer assigned by the central government, then maximum amount of fine for the offence proposed to be compounded in this section shall be twice the amount provided in the corresponding section. So in case of non-compliance, the compounding fee will be twice. Punishment in case of repeated default, supposing offence has been compounded and the same offence is repeated again within a period of 3 years, then the offence will still be compounded, but then compounding fee will be twice of the compounding fee as provided under different provisions of the Companies Act. If a company or an officer of the company commits an offence punishable either with fine or with imprisonment, and where the same offence is committed for the second and subsequent occasion within a period of 3 years, then that company and every officer thereof who is in default shall be punishable with twice the amount of fine for such offence in addition to any imprisonment provided for that offence. So the word used is fine or imprisonment. So apart from fine, the punishment by way of imprisonment can also be awarded. Permission of special court no more required. I have explained that this provision, this requirement has been dispensed with under subsection 6 of 441. Now, whether the competent authority, that is regional director or NCLT, has any discretion to reject the application, then there is a case law of the Company Law Board, which is now NCLT, in Amadhi Investment Limited. In para 14 of the said judgment, the Honorable Company Law Board held, taking into consideration the submission of the counsel for the petitioner I am of the opinion that neither the registrar of companies nor the central government or SEBI have the discretion to reject the compounding of request made by accused officer in default. That means compounding application, once it has been filed, then it cannot be rejected without adequate consideration. I agree with the opinion expressed in the book Guide to the Companies Act by A. Ramaiah, wherein it is stated that discretion to purchase peace by compounding offense or face prosecution. Either you compound the offense or face prosecution and prove your innocence in the court of law is with the accused. So that right is with the accused, whether to compound or to face punishment by court is with the accused officer in default. And once they opt for a particular posture, neither the government nor the registrar of companies has any chance except to go with their decision. That means once the compounding application has been filed and by any applicant consciously, so that he cannot face prosecution, then NCLT or RD has no discretion to reject it. Whether NCLT is power to review its own decision. So once the order is made, whether that order can be reviewed, the NCLT in the case of APC Credit Rating Private Limited versus registrar of companies, NCLT Delhi held that it is clear that there is no inherent power to review. Review can be made if there is any mistake apparent from the record. Otherwise, the order passed by competent authority cannot be reviewed. Now, various orders have been passed. I have given summary of few orders under Companies Act 1956 as well as under the Companies Act 2013. And let us see. First order is order dated 12/6/2020 passed by NCLAT. And it is in the matter of Queen Logistic India Private Limited. And these are company as well as these are the applicant's name. Then the violation is of section 166, which prescribes the duties of the directors. And period of violation is 1/4/2014 to 9/7/2017. And what is the fine prescribed under 166(7)? If any director of the company contravenes the provisions of this section, such director shall be liable, which shall not be less than ₹1 lakh, but it may extend to 5 lakh rupees. Now, you read the word carefully. It says the punishment, such violation shall be punishable with a fine which shall not be less than 1 lakh. That means this is the minimum fine which has to be imposed. But but it may extend to 5 lakh. That means the competent authority will have discretion only with regard to fine from 1 lakh to 5 lakh. So the competent authority may impose has to impose minimum fine of ₹1 lakh, but from 1 lakh to 5 lakh it has the discretion. So many times we face this situation. Then we say, we request the competent authority that 1 lakh is the minimum fine. So kindly impose 1 lakh and you use your discretion and not impose any further fine between 1 lakh to 5 lakh. And sometimes the competent authority are very liberal, and they may impose lesser penalty than what is the maximum penalty, maximum fine which is prescribed under the Act. And in such, I appeared only yesterday before the RD office, before regional director. The minimum fine not less than 50,000, which may extend to 5 lakh. Then RD told me that Mr. Jain, how much fine you agree? I requested the Honorable Regional Director that minimum you cannot impose less than 50,000, so you kindly impose 50,000. Then he said, no, I will slightly increase the amount. He ultimately fixed 70,000 per director. Now, per director has to pay this fine. Now, in one case, the application was filed. There were 7 directors, and the compounding application was filed only by 5. When I appeared before the regional director, he told me, Mr. Jain, you have filed application only on behalf of 5 directors. Those 2 directors, then if it is not compounded, then they will face the prosecution, or they have to come again for compounding. So it is better you undertake to file affidavit on their behalf. I am passing orders for all the 7 directors, and you file affidavit in today's date, and we will take it on record. So ultimately, compounding order was passed against all the 7 directors. But here, one thing is to be noted, that RD has no power vested in him to impose a fine lesser than what is minimum prescribed. But he has the discretion between, in this case, 1 lakh to 5 lakh. Now, what compounding fee was imposed by NCLT? Compounding fees of rupees 27,09,000 on Queen Logistics India Private Limited, and rupees 27,09,000 each on Mr. Robert so and so, it was imposed. Now, in another case, which is passed by Honorable NCLT, Nagendu Power Private Limited and 2 directors, Section 159 of Old Companies Act 1956. The violation was non-filing of annual return with ROC within 60 days. So earlier, the prescribed form was Form 20B. The Form 20B annual return was required to be filed within 60 days of AGM, but it was filed after a delay of 1057 days. So what was the fine prescribed under Companies Act 1956? On company and every officer of the company who is in default shall be liable to penalty of rupees 500 per day. Now, what compounding fee was imposed by NCLT? Compounding fees of rupees 1 lakh on the company and rupees 50,000 for each applicant. Supposing now the delay is of 1067 days. Now, if you multiply by 500, then how much amount it will come? It will go into lakhs. So what NCLT did? It will be 5,28,500. What NCLT did? It imposed fine of rupees 1 lakh on the company and rupees 50,000 for each applicant. Now, third case is again passed by Honorable NCLT. It is in case of Hira Power and Steels Limited, and these are the name of directors, and it is under Section 134(3)(o). This deals with CSR. So, what was the violation? Non-spending of CSR amount for 2014-15 and not making disclosure in director's report. If you recollect, under the Companies Act 2013, if supposing the CSR amount which is required to be spent is not spent, then the directors in the board of in their director's report have to give reason for not spending. If that reason is given, then it is not punishable. But in this case, what happened? The company had not spent the CSR amount, and the board of directors in their report has not given any reason for not spending the CSR amount. So there was a violation. If they had given reason for not spending the amount in their report, then it would have not be treated as violation. Now, what is fine as prescribed under the Companies Act 2013? On company not less than ₹50,000, but which may extend to 5 lakh. On every officer in default, imprisonment which may extend to 3 years, or the word is "or" with fine, so it is compoundable, not less than 50,000, but which may extend to 5 lakh rupees. So what is the minimum fine in case of company? 50,000, and the discretion is from 50,000 to 5 lakh. 50,000 has to be imposed on the company, but after that up to 5 lakh, any fine can be imposed in between. Or officer, the minimum fine is, and company cannot be awarded punishment of imprisonment. So in case of company, you will find the word imprisonment is not used. But in case of directors, the punishment can be fine or imprisonment. So in case of directors, the prescribed punishment is fine or imprisonment. So fine is not less than 50,000, which may extend to 5 lakh, and punishment by way of imprisonment, which is discretionary, is up to 3 years. Now, what the compounding fee was imposed? Compounding fees of ₹10,000 per applicant. Now it is done by NCLT. Kindly see, minimum prescribed fine is ₹50,000, but NCLT has a judicial power. So what NCLT did, it didn't impose even the minimum fine prescribed under the section 134 for violation of not giving any reason. So, and on directors, total 50,000 rupees. Next, now, next order is 30th June 2017, passed by Honorable NCLT in the matter of Stanley Engineering Fastening India Private Limited and other persons. Now it is 383A. Now the offence was continuing. Non-appointment of company secretary. Now Companies Act 1956 was attracted, which was section 383A. Company secretary, the company was required to appoint company secretary. The violation continued even when Companies Act 2013 was enacted. So it was a continuing offence committed under erstwhile Act 1956 and the new Companies Act 2013. So what is the period of violation? 1,527 days under Companies Act 1956 and 542 days under Companies Act 2013. So total days comes to 2069 days. And there were different provisions under 1956 Act and 2013 Act. What was the provisions under section 333A 1956? Company and every officer of the company who is in default shall be punishable with fine which may extend to ₹500 every day during which the default continues. So far as 1956 Act was concerned, 1527 days into 500 was the maximum fine. So far as Companies Act is concerned, the relevant section is 203 subsection 5. This will KMP. Now companies shall be punishable with fine which shall not be less than ₹1 lakh. Now earlier it was 500 rupees every day. Now it has been replaced by not less than 1 lakh, but which may extend to 5 lakh. And every director and KMP of the company who is in default shall be punishable with fine which may extend to 50,000, and where the contravention is continuing one, like this one, with a further fine which may extend to 1,000 for every day after the first. Now it is a continuing offence. Now offence has been committed under old act and the new act, and offence is of continuing nature. So what order was passed by NCLT under 1956 Act? The total fine 1527 into 500 comes to 7,63,500, and the NCLT imposed fine of rupees 3,81,750 on the company and on both directors, that means Rajesh Patil and Katsina Patrice, rupees 3,05,400 each. Now it was fine imposed under section 383A, where the quantum of fine was 500 rupees per day. Now under section 203 5, the amount of fine imposed on company was 208,400, because it was not less than 1 lakh but could extend to rupees 5 lakh. So instead of imposing outer limit of fine of rupees 5 lakh, NCLT imposed fine of rupees 208,400 on the company, and on board directors rupees 118,400, that is 1,18,400 each on the two directors. So total amount of fine, if you see, it was imposed under the Companies Act on the 1936 on the company as well as on the directors, and the directors and the company were also imposed fine under the new Companies Act 2013. Now, after going through all these orders, let us go through which sections provide the word fine or imprisonment or both, and hence compoundable. So compoundable offense list is narrowing now, because the government over the years has replaced the word fine with penalty. And where the word fine has been replaced with penalty, then adjudication under section 454 will be applicable. So now we are dealing with offences which are punishable with fine or imprisonment or both under the Companies Act 2013, and you will find section wise in this chart. So section 811, the provision is formation of companies with charitable object, and if there is a violation, then compoundable for company director and every officer of the company who is in default. And officer who is in default, we have already dealt with, it is section 2 subsection 60. Then fine is also there. Company shall be punishable for with a fine not less than 10 lakh rupees. Not less than 10 lakh rupees, so RD cannot impose fine not less than 10 lakh, but which may extend to 1 crore. Now, the discretion is between 10 lakh to 1 crore. Director and every officer who is in default shall be punishable with fine not less than 25,000, which may extend to 25 lakhs. Now, this authority is NCLT. So why NCLT has now come into play? Because the NCLT, because the fine may extend to 25 lakhs, so it can be compounded by NCLT. Below 25 lakh, it is compoundable by RD. And once it is up 25 lakhs, then it is by NCLT. Now, second is 26 subsection 9. Matters to be stated in prospectus. Supposing something is omitted in prospectus, then it is still compoundable for company and every person who is knowingly a party to issue of such prospectus. Now, what is the fine? Company and every such other person who is knowingly a party to issue of such prospectus shall be punishable with fine not less than 50,000 but which may extend to 3 lakhs because it is less than 25 lakhs. So it is by RD. Now I tell you, so far as prospectus is concerned, the SEBI has a concurrent jurisdiction. Now I dealt one case where a company secretary of a listed company, he as a company secretary, he had to sign the prospectus also, and the violation was that the company had taken a loan of rupees 15 crore from one company which was not disclosed in the prospectus, and there were many other notices, including the company secretary. The allegation was that because the disclosure was not made, then it is it attacks adjudication proceeding under SEBI Act. Now, company secretary has also been penalized by honorable adjudicating officer SEBI because this is a concurrent jurisdiction of ROC as well as this SEBI. So RD can entertain it if it exceeds 25 lakhs. NCLT can do it, but SEBI can also issue so-called notice in such cases where prospectus is involved. Now, section 40 within bracket 5, securities to be dealt in with stock change. Now, compoundable for both company and every officer of the company is in default. And what is the fine? Company shall be punishable with a fine which shall not be less than 5 lakh, but which may extend to 50 lakh rupees. Now it is 50 lakh rupees, more than 25 lakhs, it is by NCLT. So you will find a detailed list, and you kindly go through. I will request of circulation of my PPT. So to save time, I am not going to each and every section, but you can go through the PPT, and the matter, this compounding provisions will become very, very clearer when you go through all these provisions and find out the nature of violation, the minimum fine which can be imposed, which may extend to which amount, and what you can also ascertain which fine can be imposed by RD or NCLT based on various orders which I have quoted. Now, then there are offences which are non-compoundable. Now, any participant can tell me which are the offences which are non-compoundable, because I will explain which are offences which are not compoundable. Can any participant tell me which are the offences which are not compoundable? The offences where the violation incurs punishment with fine and imprisonment or both. So where the word used is and, fine and imprisonment, it becomes or both, it becomes non-compoundable. Now we go through certain sections where the offences are non-compoundable. Now, supposing some public issue is there, IPO is there. Now somebody impersonate any other person, then such application is to be treated as a fictitious application. So punishment for personation of any other person. Then liable to face any person who has impersonated. Then what is the fine and imprisonment? Fine and imprisonment. Imprisonment minimum of 1 year, but may be extended to 3 years, and with fine not less than 1 lakh, but which may be extended to rupees 5 lakhs. Now the matter will not go to RD or to NCLT. In non-compoundable cases, ROC will issue first a so-called notice Then if he is not satisfied with the explanation, he will file prosecution case with the concerned court of magistrate. And then the person concerned have to face a trial before that, because it is not compoundable. And in many cases, lok adalats are held, so it can then be settled. In such cases, supposing ROC has filed some compoundable case which has not been compounded by the concerned person, then the prosecution case has been filed, then the court may refer these cases for mediation and conciliation. Now, second is 58(6), refusal of registration and appeal against refusal. Now, in such cases, every officer of the company who is in default, every officer of the company who is in default shall be punishable with imprisonment for a term which may extend to 3 years and with fine. So my request to the participant is to go through all these sections, and then you will find which are the nature of violation and why they are not compoundable. Now we take up adjudication of penalties. If there is any question on compounding, we can take up before proceeding to adjudication of penalties. If there is any question from participant, I can take those questions.
So I believe everybody will take it last after the...
After this, okay. We will take up in the last. So adjudication of penalties, now section 454 deals with adjudication of penalties. Now, in many cases, earlier the word used was fine or imprisonment, compoundable. Now, word fine or imprisonment has been replaced with the word penalty in the process of decriminalization of offences. And because earlier it was fine or imprisonment, so both RD, both at the NCLT could award punishment by way of imprisonment also. So to accelerate the process of decriminalization, the word fine or imprisonment or both has been replaced by the word penalty, and now wherever the word penalty has been replaced, it becomes through the adjudication process. Now, who can adjudicate penalties under the Companies Act 2013? Now, the Companies Act, there is a section 454, then the Companies Adjudication of Penalties Rule 2019. So, compounding, there is no certain rules, there is no prescribed rules. But in adjudication, there is a rule which is called Companies Adjudication of Penalties Rule 2019. So you have to go through section 454 as well as the rules 2019. Now, what is the procedure? As per Rule 3.1 of the adjudication of rules, the central government may appoint any of its officers not below the rank of registrar as adjudication officers for adjudicating penalty under the provisions of the Companies Act 2013. Now, in all cases, the registrar of companies, they have been designated as adjudicating officers for initiating adjudication proceeding. Now, jurisdiction of adjudication officer, MCA has wide notification dated 24/3/2015 appointed various ROCs as adjudicating officers for adjudging penalties in their respective jurisdiction. Now, in Maharashtra, there are two ROC. One ROC Mumbai and another is ROC Pune, and both have separate jurisdiction in their respective area. And then there is a separate registrar of companies Goa. Then there are list of companies at other city in other cities. Adjudication of penalties rules, and what are the steps? First, the ROC, who is adjudicating officer, will issue a so-called notice to the company and officer in default. So so-called notice will state the nature of offense, the amount of penalty which can be imposed, what is the minimum penalty, and which may extend to which amount. So as per rule 3 within bracket 2, the adjudication officer shall issue a written notice to the company, and every company who is in default has to show cause why penalty should not be imposed. Now, supposing ROC has not issued any so-called notice, then whether any company on its own can file adjudication proceeding for availing adjudication proceeding, yes, the company can suo motu file apply for adjudication of the case. So as per rule 3 within bracket 3, every notice under sub rule 2 shall indicate the nature of non-compliance of default under the act alleged to have been committed or made by such company and officer in default. Now the officer in default definition is the same both for compounding and adjudication as given in section 2 subsection 60, and also draw attention to the relevant penal provisions of the act. What is the amount of penalty which can be levied and maximum penalty which can be imposed on the company and officer in default as the case may be. Then period of so-called notice not less than 15 days and more than 30 days. So maximum time given to the company and officer in default to reply to the so-called notice is 15 days and which can extend to 30 days. Now, if you want to avail hearing, then then I will deal with extension of period of so-called notice. As per rule 3.4, the above time limit may be extended by a further period not exceeding 15 days if the company or officer as applicable satisfies the said officer that it has sufficient cause for not responding to the notice within the stipulated time. Then opportunity of being heard, stage step 2. The act provides for providing opportunity of hearing. It is up to you to avail opportunity of hearing, or you can tell the adjudicating officer, which is ROC, that you can pass the order. So if you avail, one minute. Opportunity of heard. The act provides for providing opportunity of being heard before imposing any penalty to the company and officer in default or any other person. 454(4). Next. Now, step 3. Inquiry by adjudication officer, notice for hearing. Then as per rule 3.5, if after considering the reply given by company or officer in default or any other person as the case may be, the adjudicating officer is of the opinion that physical appearance is required, he shall issue a notice within a period of 10 working days from the date of receipt of such reply, fixing the date of appearance. So ROC may call any person for personal appearance, provided that if any person to whom notice is issued under sub-rule 2 desires to make an oral representation and has indicated the same while submitting his reply, the adjudicating officer shall allow such person to make such representation after fixing the date of appearance. The party concerned may also mention in reply that he wants oral hearing that will be provided by ROC. Then hearing. As per rule 3.6, of the adjudication of penalty rules if on the date fixed for hearing and after giving a reasonable opportunity of being heard to the person concerned, the adjudicating officer may, subject to the reasons to be recorded in writing, pass any order as it thinks fixed. So after hearing the concerned company or person in default, officer in default, or any other person, then the adjudicating officer may pass order. Now, step 5. Adjudicating officer shall pass an order within 30 days from the expiry of the period of so-called notice and such extended period. Now, what is the period prescribed? 15 days, which can be extended by another 15 days. And then if you want any opportunity of hearing, then extended time limit. Then within 90 days from the issue of notice where the person has appeared before the adjudicating officer as per sub rule. So within 30 days where no hearing takes place, 90 days where hearing takes place, then order has to be passed after expiry of this period. Every such order shall be dated and signed and shall also state reasons for requiring physical appearance under rule so and so. Now, copies of order adjudicating officer rule 3.9 shall send a copy of the order passed by it to the concerned company or officer who is in default or any other person, and to the central government, means RD, and any other order shall be uploaded, and the order shall be uploaded on website. So ROC, who is acting as adjudicating officer, will send the copy of order to the company, officer and default, or any other person to whom the order is made, against whom the order is made. He will also forward a copy of the order to the regional director, and the order shall also be uploaded on MCA website. Now, powers of adjudication officer during hearing. Now, during hearing, the adjudication officer has a power of as prescribed under Civil Procedure Code. While holding an inquiry, the adjudicating officer shall have the following powers, namely to summon and enforce attendance of any person acquainted with the facts, not only the person to whom the so-called notice is issued, but ROC can summon any other person who is acquainted with the facts and circumstances of the case. To order for evidence, now the ROC as an adjudication officer can record the evidence or may force the party summoned to produce any document which in his opinion may be useful for or relevant to the subject matter of the inquiry. So the adjudicating officer has the power to summon and enforce attendance of any other person who is acquainted with the facts of the case. He can record evidence. He can force that person to produce any document which in the opinion of the adjudicating officer may be useful or relevant for adjudication of the matter. Now, the company and officer in default, if he absents himself from the hearing, then ex parte hearing can be made and the order can be passed. Now, in case of small companies, the section 446B provides for 50% of the prescribed penalty amount. Now, you must have read the definition of small companies has now changed. Earlier, it was a paid-up capital 2 crore, turnover 20 crore. Now it has been changed to paid-up capital 4 crore and turnover 40 crore. So now these companies are treated as a small companies. And section 446B provides that the quantum of penalty will be 50% of the prescribed amount of penalty. So small companies, Small companies, I will come later on, they can be imposed lesser penalty. Now, the officer, adjudicating officer, has to consider certain factors while adjudicating penalty. Now, these factors are the size of the company, nature of business carried on by the company, injury to public interest, nature of default, repetition of default, the amount of disproportionate gain or unfair advantage, wherever quantifiable, loss caused to any investor. Now, these are the factors. Now, it is very difficult for ROC to quantify what gain the notary has made or what loss has been caused to the public at large because of these non-compliance. So he will write in the order that the gain or loss is not quantifiable. Then, if there is the repetition of offense, he has to take into account that. So the amount of penalty may be higher than in case of a single time offense. So if there is a repetition of the same offense, then there may be a larger amount of penalty. So in many cases, the ROC may use the discretion, but he has more discretion if the minimum amount is prescribed. So he has to consider all these factors, but then he has also to see, now I read provided that in no case penalty imposed shall be less than the minimum penalty prescribed, if any, under the relevant section of the Act. So irrespective of these factors will be applicable where the word used is not less than 1 lakh. So that is the minimum penalty, which may extend to 5 lakh. Then discretion is between 50,000 to 5 lakh. And in that case, he will consider all these factors: size of the company, nature of business carried on by the company, injury to public interest, nature of default, repetition of default. But these are relevant only for in the cases where he can use discretion. Otherwise, 453, 454, Red B Rule 312 very clearly prescribed that he has no discretion to impose less than the prescribed minimum prescribed penalty. Now, it creates very hardship, extreme hardship to companies where they cannot afford even the minimum prescribed penalty. And the appeal lies with the regional director. And regional director also has very clearly told in many cases that he has no power to impose lesser penalty than the minimum prescribed penalty, because he is also bound by the provisions of 454 Red with Rule 312. So even if you go in appeal, minimum amount of penalty which has been imposed by adjudicating officer will not be changed. But where the discretion has been used, he can reduce that amount. Supposing ROC has imposed minimum penalty of rupees 50,000 and also which may extend to 1 lakh to 5 lakh. So in total, he has imposed penalty of rupees, say, 1,50,000. Then in appeal, RD can reduce that penalty, keeping minimum as intact, that is 50,000, but for additional 1 lakh, he can impose lesser penalty. So the RD in appeal can reduce the amount of penalty from rupees 1,50,000 to say 1 lakh or 75,000 or any amount between 50,000 and 1,50,000. Now, under Rule 313 of the said rules, in case a fixed sum of penalties provided for the default of the provision, the adjudicating officer shall impose that fixed sum in case of default. Supposing there is no word like minimum rupees 1 lakh extend to 5 lakh, but fixed amount of rupees 1 lakh, then ROC has no discretion but to impose the fixed amount of penalty of rupees 1 lakh. Now, under Rule 314, payment of penalties shall be done only through portal of Ministry of Corporate Affairs. Under now process of adjudication, appeal can be filed to RD. Within how many days? Any person aggrieved by an order of adjudicating officer under section 3 may prefer appeal to RD having jurisdiction in the matter within a period of 60 days. So ROC as adjudicating officer has passed order. After receipt of the order within 60 days, a person can file, company can file, officer in default can file appeal before RD. From the date of receipt of the copy of the order, and the appeal should be in form ADJ, setting forth the grounds of appeal, and shall be accompanied by a certified copy of the order. So as soon as you receive the order, you apply for certified copy, because certified copy has to be attached with the appeal. Then under section 454(7), the opportunity of being heard. So as soon as the appeal is filed, the appeal will be numbered, and then RD office will issue a notice of hearing. RD may, after giving the party to the appeal an opportunity of being heard, pass such order as he thinks fit, confirming. Now RD has a power to confirm whatever order has been passed, modify the order, or setting aside the order appealed against. He can set aside the order also. Who can appear before RD on behalf of the party? Any authorized representative with his and his consent is to be attached. He can file he can represent the notary in the appeal. Now, process of appeal before result director. Endorsement of date on appeal. As soon as appeal is filed on appeal, the date on which it has been lodged will be endorsed. Then registration, stock admission. Then appeal will be scrutinized by RD office, and if it is found in order, it should be duly registered and given a serial number. Or if on scrutiny the appeal is not found to be in order or defective, the regional director may allow the applicant time which shall not exceed 14 days to rectify the default or defect. If the appellant fails to rectify the defect, the regional director may, by order and for reason to be recorded in writing, decline to register such appeal and communicate such refusal to the appellant within 7 days thereof. Now, extension of period of rectification of defect. So this 7 days period can be extended for a further period of 14 days if an appellant certifies the audit that the appellant has sufficient cause for not rectifying the defect within a period of 14 days. Now, copy of notice of to adjudication officer. Now, appeal has been filed, so hearing notice will be given, and the copy thereof will also be forwarded to the adjudicating officer, who is ROC. On the admission of appeal, the regional director shall serve a copy of appeal upon the adjudicating officer against whose order the appeal is sought, and along with a notice requiring such adjudicating officer to file his reply. Now, adjudicating officer has passed order, appeal has been filed, so notice will be served to the adjudicating officer, and he will also file his reply. Now, in adjudication proceeding, when adjudication is made, then at the time of hearing, the presenting officer from the ROC office is also appointed, and he presents the case before adjudicating officer, because he is exercising ROC as adjudicating officer, is exercising quasi-judicial power. So the case will be presented before him, and the presenting officer will explain the case to the ROC. So before adjudicating officer, there is a presenting officer who will present the case before the ROC, and in appeal, ROC has to file his reply to the appeal, which will be considered by the regional director. Now, reply of adjudicating officer. A copy of every reply application or representation filed by the adjudicating officer before the regional director shall be forthwith served on the appellant. So, as soon as the reply is filed by adjudicating officer, RD office will forward the copy of that reply to the appellant. Now, intimation of date of hearing by RD. So, RD will fix up the date. RD office shall notify the party the date of hearing of the appeal, which shall not be a date earlier than 30 days. So, 30 days time is given for hearing. Following the date on such notification of hearing is appeal. Now, hearing by RD. On the date fixed for hearing, the regional director may, subject to the reasons to be recorded in writing, pass any order as he thinks fit, including the order for adjournment of hearing. Ex party hearing, if nobody is present, ex party hearing can be passed, setting aside ex party order. If ex party order has been made and the party concerned makes representation, then RD has the power to set aside that order. Then order is signed, communicated, fine is imposed, where the company fails to comply with the order of the adjudicating officer or RD within a period of 90 days from the date of receipt of the order, the company shall be punishable with fine, which shall not be less than 25,000, but which may extend to 5 lakhs. Now, I told you for smaller companies there is a lesser penalty. Now, 446 provides, notwithstanding anything contained in this act, if penalty is payable for non-compliance of any provisions of this act by one-person company, a small company, a startup company, or producer company, or by any officer in default or any other person in respect of such company, then such company, its officer in default or any other person, as the case may be, shall be liable to a penalty which shall not be more than 50% of the penalty specified in such provisions. So not only the company, the benefit of this reduction in penalty in case of a small company is also extended to officers in default and any other person against whom the adjudication proceeding have been initiated, and this benefit of 50% penalty is available to one-person company, a startup company also, or producer company. Now, what are the provisions which are punishable with fine? Now, the word fine has been substituted with penalty by Companies Act Amendment Act 2019 and Companies Amendment Act 2020. Now, you can go through this chart. Here, earlier, the word was prescribed was fine, which was replaced by the word penalty under Companies Act, Companies Amendment Act 2019. Certain sections, the word fine was imposed by Companies Amendment Act 2020. So you can go through this entire chart. You will find that in large many cases, the word adjudication has been replaced, the word fine has been replaced with the word penalty. Now, I have also prepared a compilation of some of the orders passed by adjudicating officer. The first order is 29/8/2020. It is in the case of Cantella Solutions Private Limited, and section is 137. 137, copy of financial statement to be filed with the registrar. There was a delay of 553 days. Now, what is the penalty prescribed? Company shall be liable to a penalty of 10,000 rupees, and in case of continuing failure, with a further penalty of 100 rupees for each day. So it is continuing default. During such default continues, subject to a maximum of rupees 2 lakh rupees. It is on case of company. And the managing director, chief financial officer of the company, any other director who is in charge of the board, in charge by the board, shall be subject to a penalty of 10,000 rupees. And in case of continuing failure, with further penalty of 100 rupees for each day after the first, during which such failure continued, subject to a maximum penalty of 50,000 rupees. This is what is prescribed. Now, what is the fine imposed? 65,300 on the company and rupees 1,95,900 on officer in default, on each officer in default. Now, another order is 30th July 2022 in the matter of TR Infrastructure Developer Private Limited, Section 92(4), which deals with non-filing of annual return and financial statement under Section 137. Now, now, the delay is of 957 days in case of Section 92 days, and delay of 962 days in case of Section 137, that means financial statement. So what is the amount of penalty? In case of Section 92, annual return, company not less than 50,000 to rupees 5 lakh, and every officer in default, imprisonment up to 6 months, or fine rupees 50,000, which is minimum, which can extend to rupees 5 lakhs, or both. That means fine as well as imprisonment. In case of Section 137, where there is a default in filing financial statement, company shall be liable to a penalty of 10,000 rupees. And in case of continuing, which I have explained you above, in above case. Now, what is the fine imposed? In case of Section 92 on company, rupees 1,45,700, and in case of each director, rupees 1,45,700. Next. Next. Now, another case, 12/5/2021, in case of Baba Resorts Private Limited and its directors, Kripal Singh, Vikram Sharma, Dharampal, and Navneet Singh. Violation of Section 12(1). 12 deals with non-maintenance of registered office. Now, if ROC has sent some correspondence at the office of registered office address of the company, and that has returned back, then the ROC will assume that the company is not maintaining registered office at the place where its office is situated. So, period of violation is 32 days. Penalty prescribed is rupees 1,000 per day for company and every officer of company is in default. So, per day penalty is prescribed. Now, for 32 days, ROC has no discretion but to impose a penalty of rupees 32,000, that is 1,000 into 32 days on company and every officer who is in default. So, ROC has no discretion, he has to impose the minimum penalty. Now, another order is 24/2021, Orient Estates Limited and others. Now, offense is 203, non-appointment of KMP and company secretary. Now, the violation KMP, the violation period is 2/11/2019 to 31 कैसे हुआ? There is some mistake. It should be 18, sorry. 2/11/2018 to 31/10/2019, and company secretary, non-appointment of company secretary, 2/11/2018 to 39/2019, and against so and so. So, penalty was, as prescribed in the section, 5 lakh on the company in case of non-appointment of KMP, and on every officer in default rupees 50,000, and for continuing default 1,000 per day, but not exceeding 5 lakh. So 1,000 has to be imposed. Discretion has to be used for between 1,000 per day and rupees 5 lakh. So what is the penalty imposed? 10 lakh on the company and on every officer will default as per their term of holding of office during the default. Now, this is because the minimum penalty prescribed was 5 lakh rupees per officer. Then another order, is the order नहीं, ये तो appeal में होगा. The order passed by the regional director in appeal. The first is date of order is 21/7/2020. Name of applicant, Bright Laundry, so and so. Now section 12, where the registered office is not maintained, period of violation is dismissed. Company and every officer of the default 1,000 rupees every day during which default continues, not exceeding 1 lakh. Penalty imposed by adjudicating officer 1 lakh and on company, and rupees 10,000. Yeah, company but छूट गया है. And rupees 10,000 on every officer in default. And RD, he reduced 1 lakh to rupees 10,000 on company and rupees 10,000 on every officer in default. So he has not changed the penalty on every officer in default, which has been retained to 10,000. But so far as company was concerned, the penalty amount has been reduced from 1 lakh to rupees 10,000. Then next is 26/1/2022. In the case of Kirloskar Integrated Technologies, violation is same 203, appointment of chief managerial personnel, delay, violation is 325 days. Penalty amount, penalty provision I've already told. Then ROC has imposed penalty of 5 lakh on the company, rupees 20 lakh 64,000 on director, key manager, personnel, etc. RD reduced it to 1 lakh on the company and rupees 4 lakh 12,800 on each director and KMP. The next order is 3/2/2022. In the case of Sogefi, ADM Suspensions Private Limited, violation of is 203 again, delay is 304 days. The ROC has imposed penalty of 5 lakh on the company and rupees 8 lakh 57,500 on officer in default, which has been reduced in case of company from 5 lakh to 1 lakh, and in case of officer in default from rupees 8 lakh 57,000 to rupees 1 lakh 71,400. Then another order is under again 203 days. The penalty imposed by ROC was 5 lakh on company and rupees 1 lakh 11,000 on the director. RD on appeal reduced it in case of company from 5 lakh to 50,000. In case of director from 1 lakh 11,000 to 12,000 on the director. Then again, next case is section 92, non-filing of annual return. So ROC had imposed a penalty of rupees 6,04,000 on the company and on every officer in default 137. In case of 137, 1 lakh 33,000 on the company and rupees 60,400 on each officer. RD on appeal reduced in case of non-filing of annual return from 6,04,000 to rupees 12,000 on the 12,080 on the company and every officer in default. In case of non-filing of financial statement, rupees 2,66,000, 26,600 in place of 1,33,000 on the company, and instead of 60,400 22,660 on every officer who were in default. So similar, I have made a detailed chart. You can go through it. So you can go through these orders. Now I will deal with judgment of National Companies Appellate Tribunal, New Delhi, Register of Companies, West Bengal versus Sabyasachi Bagchi. Brief facts of the case are that the respondent Sabyasachi Bagchi was holding directorship of 17 companies on 1/4/2015 when Section 161 of the Act came into force. However, he vacated directorship of 3 companies during the period of 1/4/2014 to 31/3/2015. After receipt of the notices from the appellant, the respondent has resigned from the directorship of 4 companies on 22/12/2016. Thus, the respondent has contravened the provisions of Section 165(1) for a period of so and so, that is 326 days. The reply of so-called notice of the respondent was found unsatisfactory. Therefore, the appellant filed a complaint under Section 165(6). Register of Companies has filed this complaint against the respondent, that is director, before the Chief Metropolitan Magistrate, Kolkata. During the pendency on the prosecution, the respondent filed an application under Section 441(1) of the Act before the National Company Law Tribunal, Kolkata, for compounding the offence. The appellant ROC West Bengal filed his report on compounding application before the tribunal. After hearing the parties, the learned tribunal allowed the application subject to payment of compounding fees of only rupees 25,000 within 15 days, and the prosecution cases was then withdrawn. Next. Now there was a violation of Jain. Everyone must be aware, Ahmedabad ROC has imposed a penalty of 6 lakhs. It is appearing in many WhatsApp groups. Everyone knows about this. Yeah. ROC imposed penalty of rupees 1,50,000 on the company and 1,50,000 on 3 other directors, total 6 lakh rupees. Now 1 crore 50 lakh penalty has been imposed in the matter of Valley Monks Private Limited. Valley Monks Private Limited. The company had submitted application on ITNA for adjudication the matter. It was noted from the application that the company had allotted 50,000 compulsorily convertible debenture of rupees 103 each to the tune of rupees 50 lakh to Sri Sampat Kumar Srinivas so and so. So violation was of Section 42 of the Companies Act. The company has obtained shareholders' approval for allotment on ITNA. Though the company was compliant with respect to other applicable provisions of the Companies Act and rules made thereunder, it has missed out to mention Section 42 in the extract of board resolution. Now, only an allegation is that in board resolution, Section 42 has not been mentioned, and extraordinary general meeting resolutions and disclosures as required under Rule 14(1) of Companies Prospectus and allotment of securities rules. As per Rule 14 within bracket 8 of the Companies Prospectus and allotment rules, the special resolution is required to be filed before the issue of private placement offer from application letter. However, the company has made delay in filing a special resolution. Now, the delay was not mentioning and not this filing of a special resolution. So, what was the penalty imposed? On company 50 lakh and on directors 50 lakh each. On 2 directors, total 1 crore 50 lakhs. Okay. So, now, third is the company has not mentioned a SIN, a corporate identification number. Company filed INC 24 by SR number so and so. It is noticed from the attachment that company SIN not mentioned on the letterhead of the company. Hence, the company was directed to file adjudicating officer application for non-compliance of provisions of section 12(3)(c) of the Companies Act. Penalty imposed on company 7,000 only because the company has not mentioned its sin on the letterhead. So, company has been imposed fine of 7,000 and directors have been imposed penalty of 2,000 each. So, total 17,000 penalty has been mentioned. So, if DIN number has not been mentioned, if sin has not been mentioned on the letterhead, it attracts penalty for these lapses also. So, participant, I have concluded